Well, first of all, thank you to everyone who's been involved in this event, including those in the room who are giving up some of your scarce and valuable time to sit and listen for a while. Dean Chesney funded this and encouraged this, and we're grateful for that. I join everybody in praising Sandra Garcia and all the amazing work she has done. Thank you to the speakers who have committed their time and talent and intellectual energy and their friendship. Their papers have been enlightening, gratifying, embarrassing, and exaggerated. They remind me of how Huck Finn described Mark Twain's book about Tom Sawyer. They told the truth, mostly, but there's some stretchers. And thank you most of all to my three friends who conceived the idea for this, who recruited the speakers, who worked long and hard to find the publishing outlets. That's Rick Hassan at UCLA, who is my co-author and co-reporter on the restatement of tort remedies. Sam Bray at Notre Dame, who spent a year here at Texas. And Chris Lund at Wayne State, who is our graduate and who had the bad judgment to take every course I taught, plus an independent study. I've had a very lucky life in many ways, and this event reflects that. My parents were working class strivers. They had no idea how they would ever pay for it, but they were determined that my sister and I would go to college, and we did. And in those days, parents of children were the largest voting bloc in the country, so governments mostly paid for my education. Chicago was private, but they gave me a full tuition scholarship for 3 years of law school. The luckiest and smartest thing I ever did was to marry Terry Sullivan. A long and happy marriage is probably the greatest blessing that can enter any life. We are now at 53 very happy years and counting. It was she who brought me to Texas, and she who took me away when she became provost at Michigan and then president of the University of Virginia. And I couldn't very well say, "That's nice, dear, but I'm happy here." So thank you, Texas, for still claiming me and taking me back and sponsoring this event. Terry and I have two sons who make us proud. Neither of them could be here today. Joe and his wife, Natasha Michaels, are professors of religious studies at Texas State. I swear I never said a word to him about how maybe he should study religion. John is an analyst and number cruncher at Texas Appleseed, which is a law and policy nonprofit here in Austin. John and his wife, Hannah, produced our beautiful granddaughter, Haven, that the speakers got to meet last night. She turns 2 in a couple of weeks, and all these people have made my life very happy. When I was growing up, didn't know any lawyers, certainly no college professors. At Chicago, I had no idea that the faculty came from the top of the class. I just thought some chose to teach and some chose to practice. I practiced law for 2 years, not in a big firm, and I loved it. I was recruited into teaching. I viewed it very much as an experiment, just to see. It's worked out pretty well. So I've been very happy professionally as well as personally. But today, I could never be hired. I hadn't published a word. I had only the vaguest idea of what I might work on. My job talk was entirely oral, with no written paper, about an interesting case I'd worked on. But in those days, you could still get hired by just being a very smart young lawyer. I taught and wrote around the curriculum for a time, but gradually settled down to remedies and religious liberty, and occasionally other constitutional topics. Remedies and religious liberty are related only in the sense that remedies is related to everything. Every win for a claimant in any area of law requires a decision about remedy. I've written remedies briefs in religious liberty cases, and the clinic and I just filed a religious liberty brief in a remedies case trying to reach the conservative justices. So let me briefly hit the highlights of some of my work in these two areas. First, I'm a civil libertarian. The most important thing about my work on religious liberty, the thing I am most proud of, is that I have always defended the rights of both sides in the culture wars. I care about the free exercise clause, and I care about the establishment clause. I'm not myself religious, as Steve mentioned, and I profoundly disagree with some religious people. When those people act politically, I vote against them. I contribute to their opponents, but I defend their right to live their own lives by their own deepest values. I first endorsed constitutional rights to protect gays and lesbians and to protect abortion in print in 1981. I have actively supported same-sex marriage. I'm firmly pro-choice, and I also support the right of conscientious objectors not to assist with those weddings or those abortions. A right to believe in a religion with no right to practice that religion is a very hollow right. In some religions, practice is more important than belief. So regulatory exemptions for the exercise of religion are essential to religious liberty. We must protect religiously motivated actions and religiously motivated refusals to act. Subsidy neutrality, which Tom Berg talked about this morning, was an attempt to explain how religious exemptions are consistent with neutrality. And beyond that, an attempt to unify the whole cluster of religion clause values: neutrality, liberty, voluntarism, and separation. We measure subsidy neutrality by the government's effect on religious incentives. It is incentives that should be neutral, neither encouraging nor discouraging religious belief or practice. Minimizing government influence on religion maximizes liberty with respect to religion. And with government out of the way, any decision to participate in religion is voluntary. Any decision not to participate is equally voluntary and equally protected. And religion is, as much as possible, separated from government coercion or influence. Thomas Jefferson never said that the Establishment Clause creates a wall of separation between church and state. Most people have forgotten, but what he said was the two clauses together create a wall of separation, and he was right about that. Neutral incentives require religious exemptions in a wide range of cases because government penalties on religious conduct, whether jail or fines or loss of benefits, powerfully discourage the religious practice. But exemptions rarely encourage others to join the faith or adopt some new religious practice just because it's now legal. Many religious practices are burdensome to those who practice them. Many are meaningless apart from the faith that gives them meaning. But when a religious practice aligns too closely with secular self-interest, incentives change. Now exemption does encourage people to join the religion or to falsely claim to have joined the religion. That is why exemptions from the military draft have always come with requirements of alternative service or of paying a large fee. That is why no one ever wins an exemption from paying taxes, or why no one has won an exemption from the marijuana laws. The peyote and Wasca cases were different because those drugs had no significant recreational market. They make you throw up before they make you high. That's a marketing problem. Exemptions can also be denied in service of compelling government interest. There is no right to inflict significant harm on others in the exercise of my religion. But ever since John Stuart Mill published the harm principle, people on all sides have learned to argue that anything they don't like somehow harms them. It is not a compelling interest that your religion inconveniences me or that it offends me. We have long understood that offensive speech is constitutionally protected. Offensive religions and their offensive practices must also be protected. So I've argued for religious exemptions far more often than not in law reviews, courts, and legislative hearings. But I have also opposed exemptions in important contexts. I oppose vaccination exemptions because the government has a compelling interest in protecting everyone who comes in contact with the unvaccinated, and because the requests are mostly insincere, not based on religion at all, but on secular interest in bad science and political posturing. Before COVID, no one had ever won a vaccination exemption under a generally applicable guarantee of religious liberty. The government's compelling interest in vaccination and the phoniness of most claims were never more clear than at the height of COVID. But the judges are now as polarized as the public. conservative lower court judges began giving court-ordered religious exemptions from vaccination for the first time in our history. It was a mistake. And the legislatively granted exemptions in so many states are also a mistake. Compelling government interest can sometimes burden even the most important exercises of religion. I supported well-conceived and well-drafted restrictions on worship services at the height of COVID, but many of those restrictions were drafted quickly and clumsily, and none of them were upheld once Justice Barrett joined the court. I would exempt wedding vendors from supplying goods and services for same-sex weddings, but not if they have a local monopoly, so that no similar goods or services are available in the area. Few claims of conscience are more profound than objection to abortion. I would exempt objectors from performing them, assisting with them, or paying for them, but not in medical emergencies, and once again, not if a medical provider has a local monopoly, as Catholic hospitals often now do. If those Catholic hospitals were required to perform abortions, they wouldn't do it, but they would give up their monopoly over hospital-level OB/GYN care. So I'm accurately known as a strong proponent of exemptions, but it is less widely known I've never been an absolutist, but I'm not. Government incentives work out differently when a religious organization provides some secular service, such as education or medical care or aid to the poor. And if government helps fund those services, the substantively neutral way is to fund all providers, religious and secular alike, on neutral terms. Because unlike religious exemptions, cash has the same value to everybody. So funding the secular but not the religious, or vice versa, creates powerful incentives to add or eliminate just enough religion to qualify for the funding. Subsidy neutrality will let government speak about religion, as when UT and Texas State offer majors in religious studies, but it does not allow government to take a position on any religious questions. So no government-led prayers or religious exercises, no passive government religious displays, whether nativity scenes or crosses or menorahs or the Ten Commandments, no government endorsements of religious or anti-religious views. Chris Lund didn't talk about it this morning, but his paper questions whether subsidy neutrality can explain my opposition to endorsements. He says that a mere endorsement doesn't create much of an incentive. Fair enough, but it's a nudge. It's a government statement about what is true and valuable and worthy of public commemoration. It models a particular form of religious faith or observance, the government's form. It's a general encouragement to adopt the government-endorsed belief. And when I first introduced subsidy neutrality, I said, government should not interfere with our beliefs about religion, either by coercion or by persuasion. And some of the other religion clause values are doing some of the work here. Separation, most obviously, and also perhaps formal neutrality, no religious categories, is a kind of tiebreaker when incentive effects are small and debatable. Larry Sager and I have had a friendly disagreement about these issues for 30 years now. You heard a bit of it this morning. By now, we are engaged in essentially different disciplines. Larry's paper asks whether religious exemptions are justified in the abstract under his understanding of moral philosophy. The Constitution does not appear in his paper. It does appear in some of his other work. Neither do the reasons why the Constitution protects religious liberty in particular. One reason I would protect religious liberty is that the Constitution says so. That is not a widely accepted argument these days. But if we feel free to pick and choose, if we decide which constitutional rights we like and which ones we think are no longer morally justified, we defeat the whole purpose of a written Constitution. Stop enforcing my favorite constitutional right today, and I may stop enforcing your favorite constitutional right tomorrow. The constitutional right is to freely exercise religion, and exercise includes both conduct and practice. And that protection is both important and morally justified. I agree, of course, that the conscientious scruples of non-believers must also be protected. I've written at length about why that is so and why that is consistent with the constitutional text. But the founders had ample reason for treating religion as a category and for giving it special protection. Most important in history that was recent to them. Government attempts to suppress disapproved religions have led to persecution and human suffering on both sides of the Atlantic, and in Europe, to years of warfare and millions of deaths. To address that problem, they had to protect religious practice as well as religious belief. Religious minorities cannot live in a jurisdiction where their faith is illegal, but neither can they live in a jurisdiction where their important religious practices are illegal. So exemptions followed very quickly in the wake of free exercise. Even Massachusetts and Connecticut, the two most intolerant of the colonies, began enacting statutory religious exemptions soon after they agreed to allow religious freedom at all. In our time, we are mostly avoiding the violence so far, but religious disagreements are at the heart of our political and cultural polarization. The only way for people with such fundamental disagreements to live in peace and relative equality in the same society is to agree to live and let live. I won't mess with your deepest commitments, and you won't mess with mine. And that requires religious liberty and religious exemptions. Turning to remedies, my most prominent work has been efforts to complete the merger of law and equity. I'm not at all opposed to equity. I am opposed to its separation from the rest of our law. I want legal and equitable doctrines and remedies to be fully integrated and equally available. I want judges to choose the remedy that makes the most sense on the facts of each case. I greatly admire Sam Bray and his work, but I have never understood why he seems to think that equity is empowered by being marked off as separate, somehow subordinated to law. He would not subordinate it much. I would not subordinate it at all. The centerpiece of my efforts is an Oxford book and a Harvard article, The Death of the Irreparable Injury Rule. The argument is the same in both versions, but the book has vastly more examples. The thesis is only about the choice between damages and injunction at final judgment. Preliminary injunctions are very different. And the thesis is only about cases where at final judgment there is still a viable choice between damages and injunction. Very often the harm has been suffered beyond repair. Damages are the only option. Also very often, plaintiff chooses to repair the harm by self-help and then sue for reimbursement. And here too, damages are the only option. These practical reasons are why damages are numerically predominant, but they do not show any preference for damages in our rules of law. So we're talking about cases where at final judgment, it is still possible to prevent or undo the harm or threatened harm to plaintiffs, and where plaintiff asks for that remedy. In this set of cases, it is no longer meaningfully true that a plaintiff seeking an injunction has to show that legal remedies would be inadequate, or put another way, that his injuries would be irreparable, that they could not be repaired by any remedy at law. To put the point a bit more precisely, the historic requirement of no adequate remedy at law is no obstacle to injunctions in these cases because legal remedies are never adequate. The only exception is a narrow set of cases where the dispute is about fungible goods or services in an orderly market, and in those cases, no sensible plaintiff asks for an injunction. So if the irreparable injury rule is not driving decisions, what is? First, the plaintiff deciding what to ask for, and then the court deciding what to grant, chooses the best remedy, all things considered. It is nearly always better for plaintiffs in these cases if the court prevents the harm rather than let it be suffered and try to make the defendant pay for it later. But there may be other reasons to refuse injunctions in particular cases. So take the two halves of that comparison one at a time. Whenever an injunction is workable, it is a better remedy than damages because it actually prevents the harm. One of the classic irreparable injury opinions, more honest than most, laid out what's really at stake. If a man threatens to kill or take away his neighbor's horse, the court said, the court will not stop him with an injunction because the world is full of horses. He can collect his damages and buy another horse. Now that is tort now, pay later. And it never made any sense. The modern cases do indeed enjoin the killing or taking away of horses, and they enjoin all kinds of other threatened or continuing torts whenever there is time to do so. Contract cases tend to be less dramatic, but here too, it makes no sense to presume that promisees should have to suffer the breach of contract and seek damages later. Contract damages are very often undercompensatory because of limitation of remedy clauses, Hadley v. Baxendale, difficulties of proof, and various other obstacles to full compensation. And here I would note my Virginia colleague, Bob Scott. Bob coined the term efficient breach, and he did as much as anyone except Richard Posner to spread the idea. And now he has confessed error. Bob now says, I'm quoting here, efficient breach is both a null set and an oxymoron. So while we meant well, Charles Getz and I led a generation of scholars down the wrong garden path. That, indeed. That confession is a remarkable act of academic integrity. And it is more or less what I've been saying through 5 editions of the casebook and a whole chapter of the irreparable injury rule. But I have no street cred in law and economics. Bob Scott does. Even if the damage remedy is never adequate, there are good reasons why injunctions are often denied anyway. The injunction may be unworkable, too costly to defendant, or too burdensome to the court. This is not true in all cases, or even in most cases. Injunctions are not systematically difficult. Sometimes they are very simple, and defendants mostly comply. And damages are not systematically easy. They can be hard to measure, hard to prove, expensive to litigate, and hard to collect. But sometimes the injunction is sufficiently unworkable that damages are a better remedy, even if not entirely adequate. There are other reasons for refusing injunctions that often get rolled into the rhetoric of irreparable injury. The injunction claim may be moot or not ripe, or the court may be deferring to another tribunal. These are independent reasons to refuse an injunction, and it is just sloppiness to talk about irreparable injury in such cases, but courts often do just that. When they deny an injunction for whatever reason, they seem to almost irresistibly say, and besides that, legal remedies are adequate anyway. But when they grant the injunction, legal remedies are not adequate, even though the adequacy or inadequacy looks very much the same. Sometimes the court is protecting some other substantive law value, such as free speech or free labor. In these cases, we fear over-enforcement. Courts refuse the injunction not because legal remedies are adequate, but precisely because they are inadequate, less effective than an injunction. So the rule against prior restraints says that enjoining speech is a greater threat to speech values than damages or punishment after the fact. That may or may not be true, but that's our legal tradition. And so we don't enjoin speech, and now we're beginning to have exceptions to that. Ordering a person to work under penalty of punishment for contempt of court looks a lot more like involuntary servitude than awarding damages that likely will not amount to much anyway. Most of us can be replaced at the market wage, so contract market damages come to nothing. And for many workers, any significant damages would be uncollectible anyway, and the employer knows that and doesn't bother to sue. So there are a range of real reasons why in individual cases, sometimes an injunction is the better remedy, all things considered, and sometimes damages are the better remedy, all things considered. And most of those reasons have more to do with problems with the injunction than with adequacy of damages. I worked through these reasons in detail in the irreparable injury book. The cases cited there are now all more than 30 years old. Rick Hasson and I are restating these reasons in the tort context at least, and with plenty of citations to more recent cases. And that brings me to one final point. Emily Sherwin's paper asks whether I'm a legal realist and to what extent. Her answer to that question gets me just about right. I am a legal realist who thinks that doctrine matters. Of course, judges generally do what they think is fair and right on the facts before them. And of course, what they think is fair and right is affected by their priors. But good doctrine still matters in all those cases where the judge is not too forcefully driven by his politics or his prior commitments. Good doctrine guides discretion, and it focuses attention on the facts and issues that should matter most. Most serious defenders of the irreparable injury rule defend it as a proxy for the underlying cost and benefits of the alternative remedies. But the irreparable injury rule doesn't say what those costs and benefits are. If a judge chooses a remedy based just on the irreparable injury rule, she's acting on intuition about the right choice of remedy. and the so-called rule gives her intuition no guidance. What I tried to do in the book and what we are trying to do in the restatement is to formulate doctrine that explicitly spells out the actual costs and the actual benefits so that judicial consideration will focus on those questions. It was Carl Llewellyn, one of the great legal realists, who said that covert tools are never reliable tools. If the irreparable injury rule is really a way of referring to all the underlying costs and benefits of alternative remedies, then it's a covert tool. It never says what it actually means. Well-formulated doctrine would be a much better and more reliable tool. And if the doctrine is not well-formulated, if it's too hard and fast, if it leads to objectionable results, judges will do the realist thing and find a way around the doctrine. But I believe that even in a realist world, good doctrine focuses attention on the right questions, reduces confusion, makes for better briefs and better opinions. Maybe that makes me a doctrinal realist, or maybe a realistic doctrinalist. I'm not concerned with labels, but with getting the choice of remedies right, and with protecting the liberty of all Americans. That's the best I can do to summarize a lifetime of work in 30 minutes. Didn't get to restitution. We didn't leave much time for Q&A, but we did leave a little bit. And if you have some question or comment you don't get to make, feel free to shoot me an email. And thank you all for being here today.
Folks, we have about 10 minutes for Q&A, so if anyone wants to ask Doug a question or make a comment, please do so.
A question from the morning, and it relates to something Terry has said. On the religion side, you stand out for your empathy for the individuals on both sides. Did you come by that naturally, or did Terry have an influence?
Yes and yes. My general civil libertarian instincts reach far beyond religion, so there is that, and they apply to both sides in these disputes as well. But I was also sort of marginally placed to observe religion in all sorts of ways. I grew up in a Methodist church that was high church in the morning and evangelical in the evening. And my parents went through phases, but there were years when we went to church 3 times a week. And all my country relatives were in evangelical churches. So I was exposed to all of that. And obviously I was exposed to a brilliant, devout Catholic in my marriage, but also at Chicago to a whole cluster of very smart, highly educated, active Catholics, including Andrew Greeley and a network of people from the old Irish neighborhood and the southwest side who were around him. So I was exposed to all of that. So, exposure obviously broadened perspectives and no doubt increased empathy. But the basic instinct is everybody's entitled to their own liberty, whether in religion or anything else.
Doug, I actually have a question for you from Nate Chapman, since he couldn't be here today. He texted it to me. He's wanting to know, how much did your time at the University of Chicago shape your theories on religious liberty, particularly with regard to incentives? He notes that you and Michael McConnell seem to have reached this kind of same idea about incentives around the same time, and he's wondering how much your exposure to the law and econ folks at University of Chicago may have impacted your thinking on substantive neutrality.
Life isn't fair. I published substantive neutrality in a lecture at DePaul in 1990, and that same spring, actually, Michael McConnell and Richard Posner did a co-authored article on law and economics as applied to religious liberty. I had not seen the draft. He hadn't seen mine. We both came up with the same idea. I called it substantive neutrality, put it in the title, and it got a lot of attention, and here we are. They called it incentive neutrality, which is a much better name, much more descriptive name, buried in subpart 4, and it got no attention whatever. So I've gotten all the credit, and he hadn't gotten any, but he invented the same idea at the same time. I don't think Chicago influenced it. This is 1990. I've been gone from Chicago 9 years at that point. I was Posner's student. I reacted very negatively. I thought law and economics was one of the worst, most ridiculous, most damaging ideas I'd ever encountered. I've mellowed, but I still think it was. Well, one way I describe my time in Chicago was, by the time we left, I realized we'd had the same argument at lunch every day for 5 years, and the argument was, does economics explain all the important things in the world, or only some of the important things in the world? So the Chicago influence was not great. I created the idea here at Texas.
So I want to ask you a more of a meta question than a doctrinal question, which is, if you look around the room, this is a room full of liberals and conservatives, and that's pretty rare in legal academia. And so what is your advice about how to be able to be true to your own ideals and not cut back on what you think, but still being able to build bridges and across political divides and lower polarization, which I think we need a lot more effort in that area, especially today?
I don't think I have any advice that is not obvious, but it is the point about live and let live. And the problem in my field is that on both sides, on both the conservative religious side and on the feminist LGBTQ side, both sides want a total win. They want utterly unrestricted freedom for their side and essentially no freedom at all, or keep it hidden in the church or keep it hidden in the closet for the other side. They maximize their interpretation of whatever constitutional provision protects them, and they minimize or dismiss whatever constitutional protection protects the other side. And they would both be happiest if the other side just disappeared from our national community. Until we get past that, there's no progress, right? We have to be willing to say, the other side gets to live their lives by their own values. I'll be irritated about it. I'll sometimes be inconvenienced about it. I may only get my way 95% of the time instead of 100% of the time, but that's okay because they're only getting their way 95% of the time instead of 100% of the time. The number of cases in the middle where someone just has to give up and lose, really pretty small. And my point about local monopolies are about those cases, right? If you're the only wedding vendor in town, and we're in West Texas and the next town is 200 miles away, either you have to provide me or I have to do without. We just have to choose. But mostly we do not have to choose. Mostly each side can exercise their own rights without really violating or infringing any rights of the other. But the other side is irritated about it. That's our fundamental problem.
Doug, can I, your comment about Chicago and the law and economics made me wonder, both as your time as a student and later teaching there, the influence or any influences of the non-economic law and economics group. I'm thinking about Richard Helmholtz and I don't know the overlap with John Langbein, Brian Simpson, and maybe especially Owen Fisk, because I don't know if he was there when you were a student. So I'm curious about the other influences outside of economics.
Well, the dominance of law and economics in Chicago was never numerical. There were only a handful of really hardcore people. The problem was they were so outspoken and so evangelistic, they dominated every conversation. They dominated every workshop and colloquium. But there are all sorts of other people there. And if you had arrayed the Chicago faculty in my time, when the law and economics thing was at its peak, if you arrayed them politically from left to right, the median faculty member would not have been far from the median voter. Might have been to the left of the median voter. So there were all sorts of other influences there, and I reacted much more positively to many of them. I was Owen's student, took his injunctions course, was hired at Chicago the year he left for Yale, so I took over his injunctions course. That's how I got into remedies. So yeah, there were lots of other influences going on. Anybody else?
Doug, what you were saying earlier about not having a winner take all on both sides of the culture war debates, I have to wonder if that was relevant to Justice Kennedy. And I think the credibility of you and Tom Berg on this issue may have mattered a lot, having principally defended people on both sides. And I've often thought of Masterpiece as the other end of the deal from Obergefell. And Obergefell were saying government doesn't get to pick one right view of marriage and punish those who are doing it differently. And then in Masterpiece, it's sort of saying the same thing, but from the opposite point of view, from a religious liberty point of view. I wonder if you think that that's accurate, or if you have other thoughts about, I guess, other ways in which, outside of just the service context, there are ways to find live and let live solutions in that LGBTQ context, especially as we see in some states the resistance to RFRAs. There has been some success in that area recently. So if you want to speak any more to any of that, I'm just really interested in your experience.
I don't know what was motivating Justice Kennedy. Occasionally, filing an amicus brief is like playing in slot machines. You get intermittent reinforcement, but it's very intermittent. Occasionally, you can see that you actually made some difference. And most of the time, you have no idea whether anybody even read it, or let alone cared about it or was influenced by it. Masterpiece Cake Shop, that's the baker in Denver who wouldn't do wedding cakes for same-sex weddings. That's a deeply cryptic opinion, and everyone on the gay rights side wants to say it's only about the hostile comments that this stupid commissioner made at the hearing. He should have had better sense and only thought those things and not said them. But the opinion also talks about the religious guy who went and asked for an anti-gay rights cake and was turned down, and the Colorado authority said that's not a violation. And Kennedy talks about that, and so the opinion is very much open to the interpretation. They created a secular exception to the discrimination law, so they have to allow a religious exception. And it remains ambiguous. Whatever he meant, whatever the 5 votes thought they were doing, the 6 votes now are so gung-ho for free exercise, we can be confident that gay rights exemption claims are going to win at the Supreme Court by one opinion or another, and for better or worse. And I'm glad they have revived the free exercise clause. I really do think they're going too far in some ways. I don't have any confidence they'll find a sensible stopping point, but they may. There's something else you said, but I've lost it.
Okay, can we give another round of applause for Doug?